When you think about a country's constitution, you probably picture one single, powerful document, right? But what happens when you lay all of those national rulebooks out on the table side by side? Well, that's when you step into the world of comparative constitutional law, a fascinating field that's built around one big fundamental debate.
So what exactly is this field? Before we dive into the nitty-gritty, we've got to tackle the one question that defines the whole thing. Is comparing constitutions a kind of science where we're looking for universal truths, or is it more of a practical method? A toolkit for solving real-world legal problems. And trust me, the answer is not as simple as it sounds.
So this really lays out the two big camps. On one side, you have scholars who are convinced this is a pure science. They believe that if you just study enough constitutions, you can uncover universal principles, almost like laws of political physics that should apply to every country. But then on the other side, you've got jurists who say, whoa, not so fast. They argue it's not about finding some secret rule book at all. It's a method, a way of looking at legal problems by seeing how other countries have already tried to solve them.
Okay, so keeping that big debate in mind, here's the textbook definition. At its core, comparative constitutional law is all about systematically looking at the similarities and the differences in how countries set up their governments and protect their people. It's basically pattern recognition on a global scale, finding the common threads and the totally unique solutions that make each nation what it is.
Now, the method camp feels so strongly about this that two of the giants in the field, Rudolph and Schlesinger, basically said the name of the field itself is wrong, a misnomer. They argued it's totally misleading because it makes you think there's a fixed set of laws when it's really all about the process of comparing. This idea is so powerful that in Germany they don't even call it that. They call it Rechtsvergleichung, which literally just means law comparison. It frames it as an action, a method, not just a subject you study.
Okay, so if it's a method, what's the point? Why bother with all this comparing? Well, it turns out the real-world applications are absolutely huge. This stuff shapes everything from high-stakes international deals to the fundamental rights you and I rely on every single day.
This method has at least 6 crucial jobs. For instance, when diplomats are negotiating, understanding another country's constitutional red lines is a total game changer. Back home in the courtroom, a smart lawyer can make their case way stronger by pointing to how another country's court handled a similar issue. And for a nation itself, comparison helps keep the government in check, figure out thorny issues like the power to declare war, and, this is a big one, it allows the Constitution to actually grow and evolve with the times.
And that leads us to one of the most powerful and honestly beautiful ideas in all of constitutional law, the living tree doctrine. The whole concept is that a constitution isn't some dusty old document frozen in the year it was written. No, it's meant to be an organic, living thing that can adapt to new technologies, new social values, and new challenges, growing and changing right alongside the nation it serves.
And if you want to see this living tree idea in action, well, we just need to rewind the clock to a single landmark year that completely transformed workplace rights in India.
So picture this. It's 1997, and India had a major legal gap. There was no specific law on the books dealing with sexual harassment at work. So what did its Supreme Court do? It looked outside its own borders. It drew directly from a major international treaty, the UN Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW. Using the principles from that global document, the court created legally binding rules for the entire country. That is a perfect example of the living tree at work, using international ideas to make a constitution's promise of dignity a reality for its citizens.
Now, this idea of comparing different ways to run a country is anything but new. This debate over the best way to govern is a conversation that stretches back thousands of years, all the way to the dawn of Western philosophy.
The real pioneer here, the OG of this whole field, was Aristotle. And he didn't just sit around and think. He got his hands dirty, systematically analyzing 158 different constitutions from various city-states. He sorted them based on 2 simple questions: who's in charge, and are they ruling for the common good or for themselves? But here's the fascinating twist. For Aristotle, what we call democracy today was actually a bad thing, a perverted form of government where the poor majority could just run roughshod over everyone else. His ideal was something he called a polity, a mixed government balanced by a strong middle class.
So after the Greeks laid all this groundwork, the Romans came along and brought the whole enterprise to a screeching halt. They were so utterly convinced that their legal system was the best in the world, with its laws for citizens and laws for everybody else, that they saw literally no reason to look outward for ideas. And that confidence plunged the field into a dark period that lasted for more than 1,500 years. The big comeback happened during the Enlightenment. In 1748, a guy named Montesquieu, often called the father of modern comparative law, published The Spirit of the Laws, and it was a game changer. Soon after, the American and French revolutions created a desperate, practical need for new ways to set up a government. That spark of interest grew and grew until the field was formally recognized in the 1800s, and finally, in 1900, the first ever International Congress of Comparative Law made it a global academic discipline.
So let's see how all of this history and all this theory actually gets put to work when you're building a modern nation from the ground up. And there is perhaps no better example of comparative law in practice than the creation of the Constitution of India.
This brings us to a really crucial distinction, a phrase you've got to remember. The Indian Constitution was adapted, not just adopted. The people who wrote it didn't just copy and paste a blueprint from somewhere else. No, they did a massive comparative study, borrowing some of the best ideas from all over the globe and then carefully reshaping them to fit India's incredibly unique culture, society, and history. And you can literally see this incredible patchwork in the final document. The parliamentary system, heavily inspired by the United Kingdom. That powerful list of fundamental rights, that is big USA vibes. The guiding principles for the state came from Ireland, the federal structure from Canada, and even the emergency powers were adapted from Germany's Weimar Republic. But the real genius wasn't just in the borrowing, it was in the remix. It was in how they wove all these different threads together to create something totally new, something strong enough to hold a vast and diverse nation together.
But let me tell you, this adaptation process was not some easy, straightforward thing. It was full of fierce debates. For example, take the idea of a uniform civil code, a single set of personal laws for everyone. On one side, you had people like K.M. Munshi arguing that a modern, secular state needs one law for all. But on the other, you had voices like Nazaruddin Ahmad warning that forcing this on communities without their consent could trample on religious freedom. This one single debate shows you what an incredible balancing act it was to fit these global ideas to local realities.
And that brings us right up to today. In our hyper-connected world, the work of comparing laws is more important than ever. But it's also facing a whole new set of really complex challenges.
And these challenges are pretty significant. I mean, how do you translate a deep legal concept from one language to another without losing its soul? How do you remember that a law that worked perfectly in one political culture might completely fail in another? And critically, how do we avoid legal imperialism, this subtle bias of just assuming Western models are the best, and instead learn to look past the written words to see how a constitution actually works for people on the ground?
And part of the challenge today is that our very definition of what a right even is keeps expanding. The first generation was all about civil and political rights, free speech, the right to vote. Then came the second wave, economic and social rights, like the right to an education or healthcare. More recently, we've seen third-generation rights emerge, like the right to a clean environment. And now we are just entering a fifth generation, forced to ask brand new questions because of things like AI and biotech.
This leads to a final, really critical distinction. Human rights are those universal moral principles we think everyone on Earth deserves, but fundamental rights are the specific human rights that a country has actually written into its constitution, making them legally enforceable in a courtroom. So, for example, a lot of us might feel that internet access is a basic human right today, but it only becomes a fundamental right when a country officially recognizes it, and you can actually sue the government if they deny you access.
Which leaves us with this final thought. Right now, we are confronting these fifth-generation challenges that the writers of most constitutions could never, ever have dreamed of. Artificial intelligence, gene editing, blockchain. The work of looking across borders for wisdom, for innovative ideas, has never been more vital. So the real question for all of us is, what new ideas will we need to adapt to build the rulebooks for tomorrow?